Hello guys, and welcome to another episode of my lecture. This is Olayeni Diekolola Daniels, popularly known as Dieko Spectre. And on today's episode, we will be talking about the Maxim 3, which is where there is equal equities, the law shall prevail. Now, in my last class, I talked about the fact that equity will follow the law. And I will advise that if you have not watched the last episode, you should kindly go to my Law of Equity playlist and watch the Maxim 2, which is the fact that equity will follow the law. And before that, I talked about Maxim 1, which is the fact that equity will not suffer a wrong without a remedy. So please make sure you watch these two lectures before you watch this one, so that it can give you proper perspective as well as context. So like I said, the Maxim 3 is what we are discussing about today. Where there is equal equities, the law shall prevail. Now, if this is your first time of coming to my channel, please make sure that you click the subscribe button and make sure that you click the notification bell, so that anytime I release a video of this nature, which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. And also, do not forget to follow me on LinkedIn at Diekolola Daniels. Thank you very much as you do so. So going straight into our lecture today, where there is equal equities, the law shall prevail. Let's go through the notes to get a perspective before I finally explain. Now, this maxim means that where a question as between competing interests arises and two or more of the competing interests have equal merit in the eye of the law, the one with the legal interest takes priority over equitable interest. This maxim governs the position where there are competing interests in property, one of which is a legal interest, the other equitable. Where the claim of both parties are equally fair and meritorious, precedence will be given to the legal interest. The operation of the maxim may be seen in the following hypothetical illustration. Now, I don't want us to go to the illustration without getting an understanding. Now, I want you to know that when you get to court in relation to rights, in relation to properties, there are always conflicting interests. So let me give you an example. Oshodi, his name is Oshodi. Oshodi has a land. Are you listening to me? Then Oshodi sold that same land to somebody, but Oshodi did not put it in writing. Don't forget that when I was teaching you equity follows the law, I taught you something on statute of frauds. And I told you that according to the statute of fraud, you are supposed to put that thing in writing. Because when it is not in writing, then you cannot have a legal interest. What you would have is equitable interest. But Oshodi, when he was selling this property to Fayinka, Oshodi did not put it in writing. Therefore, Fayinka cannot have a what? A legal interest. The highest Fayinka can have on that property is what? Equitable interest. That same Oshodi sold that property to Temilade, for example. Now, Temilade, because he's a lawyer, then asked, "Hey, Oga, I know what is statute of fraud talk. Yeah. Come and put it in writing." They put it in writing under a deed, and that deed was registered. Now, we have two competing interests on that same land. We have the first interest, which is equitable. We have the second interest, which is legal. And you must know that for every legal interest, there is an inherent equitable interest. Put that at the back of your head. For every legal interest. So, for example, Temilade who is a lawyer and said we must have this in writing, has a legal interest, and inherent in him there is an equitable interest. Therefore, there are two competing equities. The first equity of who? Of Fahimka, and the second equity of who? Of Tiwalade. So where there are two competing equities, the law shall prevail, which means because Tiwalade has a legal interest but Fahimka does not have a legal interest, Tiwalade would have priority regardless of the fact that Fahimka came first in time. Let us say he gave the land to Fahimka in 2005, that's 2005, and then he sold that same land to Temilade in 2010. That's 5 years difference. Still, if the case goes to court in 2015, Tiwalade will win, or Temilade rather will win, while Fahimka will lose. Why? Not lose in the sense that she is not the owner of the land, but lose in the sense that someone else has priority over her interest, and that person will take that land while she will not, because he has legal interest. So I think I've given you a perspective, because this illustration seems to be a little bit, not straightforward. Now, so in relation to our illustration, A acquires an equitable charge over Blackacre, and Blackacre is worth 4 million naira. Now, Blackacre there is the land. Let us say Banana Island. This illustration says what? Blackacre, but let us use Banana Island. Now, A acquires an equitable charge, meaning that the owner of the property is not A. The owner of the property is C. C needed 1.5 million. So C went to A. A, please give me 1.5 million and I will give you an equitable charge over my property, which is at Banana Island, but in this case, Blackacre. Do you understand that? So, by the virtue of the fact that it is an equitable charge, you don't need the babalawo to tell you that means that is an equitable interest as opposed to a legal interest. So, the fact is that, number one, we have A who gives C 1.5 million because he wants to use it as a loan, and then he gets the house that is at Banana Island. He gets an equitable interest over the house. But guess what C did? C, who is the owner of the land and who collected 1.5 million from A, and use the property in Banana Island, in this case Blackacre, as collateral, then went to B and then collected a legal mortgage of Blackacre, still worth how much? 4 million. Also to secure a loan, that is to collect 1.5 million from who? From B. B had no notice of A's equitable charge when he lent the money, and now the value of Blackacre has dropped to 2 million. Here, B is entitled to be paid the full amount of his loan, which is 1.5 million, from the proceeds of the sale of Blackacre, because apparently C has jackpot as usual. And now, A must be content with what is left, which is 500,000, since B's legal interest take priority over A's equitable interest. Now, if on the other hand, before he lent the money, B had received notice of A's equitable charge, B would not gain priority over A, and the position would be reversed. Since there would not be equal equity, equity would not allow the carelessness or imprudence of B in lending the money, knowing of a prior charge on the property, to defeat the interest of A, the innocent party. Now, what we are saying, the Japanese that we just said now, is very, very simple. What we are saying is this: where you have a legal interest over a property and then you have an equitable interest over a property, the legal interest will always take preeminence. For example, in this case, we have B. B has legal interest over the property, but A has only but an equitable interest. And where the property diminishes to 2 million as opposed to 4 million original value, then B is going to get full price. That is his 1.5 million that he gave as a loan, because he has a what? A legal interest. Now, there is a little bit of exception to that. In the event that B knew of A's interests, Are you listening to me? If B had notice of A's interest, then B will not be said to have priority anymore. But that is only if B knew of A's interest. In one of my videos on equity, I taught actual notice. In subsequent videos, apart from this set of classes, I will teach the other kinds of notice that we have. We have actual notice, we have implied notice, and we have constructive notice. Those are the three types of notices in equity. And then I told you when I was teaching actual notice, I told you that when you see a property, for example, and then you see someone write, beware of 419, do not sell, we are not selling, or something like that, just to give you notice that if you carry money and invest in this property, your money have burned. Don't let anybody come and deceive you, because people are very, very dubious. We don't write down for this property. And I gave you an example of a married man. I said that where you see a ring on a married man's hand and you still, said, well, you are doing it at your own risk and at your own detriment, because he's married, and you still want to say, oh, maybe. There is no maybe he is married. The same way you get to a building, you are saying beware of 419, you are saying, oh, well, maybe. If you put money inside that building, your money will catch fire. It's not they are not arguing it. Do you understand what I'm saying? So in the event, let us say when A acquired that equitable charge, A went to the property and wrote all over the property, do not sell, this house is not for sale, or something, in order to secure his own money, because he knows that the C, who is the weary that he got the equitable charge and all that from, that one can go and sell it to someone else. So in order to protect his interest, he went to the house, he wrote, there is no loan or whatever it is, please don't communicate with anybody, or one way or the other, in order to serve as notice to the world. Now B now went to the same place and then got a legal mortgage, regardless of the fact that the interest that B would have is legal. If B knew of A's interest, let us say when C went to meet B, that okay, I want to collect 1.5 loan, someone hinted A, and A went to meet B and told B, I have an interest on this property, I've given this same person 1.5 million, he has not returned it, and all that. Now, regardless of the fact that A has only an equitable interest, the moment A gives B notice, or the moment B has notice by way of seeing anything around the house to show that A has interest, then B's interest cannot and will not be taken over A's interest. Are you listening to me? B's interest cannot and will not be taken over A's interest. A's interest is going to be of priority regardless of the fact that it is only an equitable interest. Now let us look at the cases. We have two cases for us to look at, two very interesting cases. The first one is the case of Pilcher versus Rollins. Now X in this case is the sole surviving trustee of a trust fund for the benefit of A's life, and after his death, his children. Now the same X lent R money, and R fraudulently, by omitting the mortgage of X in the abstract of title, so that the fee simple apparently remained in R, conveyed the legal estate to B by way of mortgage. Now, for you people who do not understand this, let me try to break it down for you. Now, you have X. Are you listening? X is the sole surviving trustee. What that means is maybe there were about 3 to 4 trustees. Someone died and then gave 5 million, or let's say 50 million for his son. That's A. His son, when his son is old enough, the son is supposed to hold the whole of the 50 million, and if the son should die, then the 50 million should go to any of his children. Now, in this case, X is now the sole surviving trustee, which means out of the 5 trustees for that 50 million, 4 have died. Now X being the sole surviving and A still being very, very young. I know that money depreciates in value. Money is very, very fickle. It's so fickle that the 10 million naira of 2000 is not the same 10 million naira now that we are in 2022. If you understand what I'm saying. The 10 million naira of now compared to what it would have been in 2000, it would have been about 1 million. The 10 million naira of 2000 is 100 million naira of now. If you don't understand what I'm saying, as at then, if you wanted to buy a property with 10 million, there were so many properties you could buy. But as at now, I think the only thing you can buy with 10 million, I think, will be land or something. But, it depends on the area we are talking about. But if we talk about Lagos and certain parts of Lagos, 10 million naira would not even buy, quality land. Do you understand what I'm saying? But as at 2000, that same area, 10 million naira could have bought a house. Do you understand? So because of inflation and because money diminishes, money is so fickle that you have to, invest and all that. X now said, okay, I don't want this money to diminish by the time this guy is old enough. And he's going to be old enough, let's say as at that time he was still 5 years old. That means he still have 13 years. And this 50 million that your father has given us, by the time you are 18, this 15 million is going to be 5 million. You know what? Let me use it as a form of mortgage so that this person will give me an interest. So this is what he did. He gave the 50 million, that's X, gave the 50 million to R and said, R, take 50 million and then in the next 5 years, give me 100 million. So that I can keep, turning the money like that. If I continue like that by his time, that is the time that A becomes 18. That is in the next 13 years. Then, you will have about 150 million thereabouts. That's a very smart move. So he gave R this money, and then because it wasn't in writing, it was definitely an equitable mortgage. You know what R did? R fraudulently, in the abstract of title, for those people who do not know what abstract of title is, when you want to buy land from somebody illegally, that's according to the law, you are supposed to collect what is known as a deed of assignment of interest. You see that deed of assignment, it has certain parts, but the first set of parts is something called abstract of title. Abstract of title, which is also part of the recital of the deed, is going to tell you the people that have owned that land before this person that is about to sell it to you. Do you understand that? So, between the years of 1999 to 2002, Mr. Ologbela held this land. Then Mr. Ologbela in 2002 sold it to Mr. Kashimawo. Then Mr. Kashimawo in 2005 sold it to Mr. Azan. Then Mr. Azan in 2000, do you understand? Up to the current Mr. whoever it is that owns the land now. And also, if there are other encumbrances or other mortgages and loans that you have taken in relation to that land, then it will also be in the abstract of title. But do you know what R did? R then fraudulently omitted to put it in the abstract of title when he conveyed the legal estate by way of mortgage to who? To B. So we have X who has an equitable interest, we have B who has a legal interest, but B has no notice of X's interest, and that money is not X's own. The money belongs to A. X was just doing a good thing by trying to invest the money so that when A comes of age, the money would not have diminished. But what would the court say in relation to this? Let us look at the issue. The issue, which is the question for determination, was whether A or B has priority over the land. And then the court held that B had acted reasonably and honestly and had no notice of the earlier mortgage transaction, and he was entitled to priority over A, whose interest was only equitable. So you can see what I'm talking about. When I told you that equity follows the law, I also explained to you that equity respects the law, regardless of the fact that A did not even know anything about this. X was saying, please, I want to help you and all that. Now A, when he has come of age, now went to the person that had the property and said, I have an equitable interest. But the person said, well, me, I have a legal interest. Now they went to court, and that is the case. So I hope you understand this. Where there is no notice, the legal interest will always be prioritized over the equitable interest. And interestingly, I would like us to go to the next case, which is the case of Joseph versus Rollins. A assigned, that is equitable, for valuable consideration his stock in trade to the plaintiff, subject to a proviso for redemption. Before the plaintiff took possession of the after acquired stock, A pledged, now legal, it to the defendant who has no notice of the assignment. So now there is legal assignment and there is equitable assignment. Now A assigned equitably, A assigned equitable interest for valuable consideration is stock in trade to the plaintiff, subject to a proviso for redemption. What is stock in trade? Stock in trade are those things that you use in conducting your business. So for example, if I own a very large company where we manufacture cars, and all of a sudden I don't want to be, in the manufacturing of cars anymore. I don't want to be in that line. I want to go into music. They've called me to come and start singing. Now all my equipment in the company, I want to assign it to somebody equitably, because there is no agreement formal and all that. So I assign it to somebody, and then I assigned it to A, for example. But before A can take possession of everything and now pledged it legally, I pledged it to B, and B has already come to take possession. Now A now went to court. The court will say, yes, A, you have an interest. That's right. Not only do you have an interest, you came first in time. That's right. However, we have to look at, do you have an equitable interest? Okay, it seems you do. If you do, then the second interest, the second competing interest, is it a legal interest? Wow, it seems it is. If it is, does that second interest have notice of your earlier interest? If it is not, then A, I'm sorry, but at this point you have to go home, because equity cannot help you. Do you understand that? And that's what happened in this case. The issue was who between A and B should have priority of interest over the stock in trade. And now the court held that the plaintiff interest was equitable and the defendant's interest was legal. And since he had no notice of the plaintiff interest, he had priority over the plaintiff. And that exactly, ladies and gentlemen, is what I am telling you about. Then let's go to the latter part of my note. The consideration of the doctrine of notice and statutory enactment affecting it is very essential to the application of this maxim. The purchaser is bound by all equities which he discovers on investigation, or which he would have discovered had he been diligent. His notice is either actual, constructive, or implied. I already told you that before. I have made a video on actual notice. You can check it. In my subsequent set of videos, I'll make a video on constructive and also another on implied notice very soon. Now similarly, if he engages an agent to act for him, he is bound by all equities which the agent discovers, which is constructive notice, by the way, during investigation, and those he should have had he acted with reasonable diligence. Now this has been a very beautiful lecture. We have learned that where there are equal equities, what will happen? The law shall prevail. However, for the law to prevail, it must be such that the law had no notice of that equitable interest, because if the law does have notice, then that would mean that the equitable interest shall prevail over such legal interest. We have looked at the case of Pilcher and Rollins and Joseph and Lyons, and at this juncture I think that we've had a very beautiful class. Thank you so much for watching to the end of the lecture. Make sure that you subscribe, like, and share this video with your friends. And next lecture we would be talking about where equities are equal, the first in time shall prevail. Now also make sure that you follow me on LinkedIn, and it has been such a very beautiful class. I will see you in my next lecture.